Chair at this time lays out House Bill 65 by Representative Krause. And
Good afternoon, committee. Yeah. This bill is also aimed at divorce reform type measures, and what all this bill simply says is that when there's a divorce proceeding, right now the time is 60 days. We want to extend that from 60 to 180 days, so 6 months, if children are involved. And the genesis behind that is so many times when kids are involved, the divorce proceedings take longer anyway, just by nature of the proceedings. There's so many things that go into it. There's so many different moving parts and mechanisms. Where are the kids going to stay on the weekends? What are we going to do here? What school are they going to go to? Where are they going to live? That just with kids, it creates a different environment. There's a lot of different factors that you have to look at. So we think going to 6 months, which puts us in line with a lot of the other rest of the country. This is no by means novel or something new, but increasing that waiting period, I think, will go a long way. We found that even when you do it in 60 days or 80 days, a lot of times you have to come back to the court and get a modification. You have to get changes to the agreements that you've already put in place because they were done so quick you didn't take into account all the factors. So we think this makes a lot of sense just for planning purposes, for the kids to not disrupt them as much as they need to. It usually lets them at least get out of the school year that they're in, and I think it's just beneficial all the way around. So I'll reserve the right to close. Happy to answer any questions. But
now, Mr. Krause.
Yes, sir.
Let me ask you a question. Or any, I don't know, maybe you do. Are any of these divorces based on the grounds of insupportability, are they ever resolved within 180 days of filing?
We've done some research on that. Very rarely. We have seen some cases that have done that. Usually it seems like they have to come back to the court again for those modifications or some change to the agreements they put in place before that 180 days. But for the most part, it takes more than 180 days.
Before they get.
That's right. So the 60 days, it doesn't really come into factor one way or the other, but in certain circumstances it has happened.
Okay. Any other questions for Mr. Representative Krause? Not hearing any, we'll reserve the right to close for you. Oh, yeah. Mr. Chairman Moody has a question.
The information on the resolutions, where'd you do your research at with?
The information on the resolution of the cases. We talked to various family law attorneys. Cecilia Wood, who was here earlier, who's practiced family law for a long time. We've talked to her extensively. She's got a lot of personal knowledge and done some other research for us to get those.
Is there because I know we have Office of Court Administration that looks at dispositions of cases. Is this something that they would have access to, that we could find data across the state?
Yeah, I think they would. Yeah.
Thank you.
Representative.
Yes. Ms. Theory has a question.
Thank you, Mr. Chairman. So the exception to this would be in the event of family violence. So there is an exception for that.
Right, absolutely. You want to get that done as quickly as possible.
Okay, so what would they do to prove that? I'm trying to read it very carefully. It says a waiting period is not required where the respondent has been finally convicted of or received deferred adjudication for an offense involving family violence. So that would be in a situation where the respondent to the divorce was already convicted of a family violence situation?
That's right.
Okay.
That's correct.
Can I ask a question?
Chairman Moody has a question.
Based on that, would you be amenable to making that finding based on the finding that's made in a protective order that precedes the criminal conviction?
Yeah, absolutely. So you're saying not having to wait till it's finally adjudicated?
Because those cases can drag for quite some time, longer than 180 days. And if that's the allegation, however, though, and you're going to have your temporary and then your 2-year protective order that'll get entered into on the front end of that case, and that determination will be entered into by a family court judge or associate judge on the front end.
Absolutely. Yeah, we'd be willing to amend it that way.
Right. Okay. Thank you. We'll reserve the right to close.
Thank you, Chair.
At this